Welcome you all to the session on Factories Act 1948. Factories Act 1948 is one of the most important and regulatory piece of legislations. It governs the safety, health, welfare and other working conditions in a factory situation. This is an extremely important piece of legislation which everyone has to know and then implement and be compliant with the provisions of this Act. Actually, this Act, though it is enacted in the year 1948, still it holds good even in spite of several modernization has taken place, new machines have been set up on account of lot of technological developments, and computerized machines have come, and improved layouts have come. Even in spite of the fact, the specifications mentioned in the Act still holds good today. One must really appreciate the persons who drafted the 1948 Factories Act, which contains a lot of technical details and technical specifications which regulates the health and safety of the workers. Now let me take you through a little background of the legislation, what are the circumstances led the government to formulate this important piece of legislation. As we know that in 1951 and 1855, the textile mills and jute mills were started. This was the beginning of the modern factory system in India. And after 1851 and 1855 thereafter, number of factories came up in both the regions, like particularly in Bombay and in Bengal. On account of the new modern factory system, there was need to regulate the working conditions. The workers were not satisfied with the working conditions in terms of working hours, engagement of women, child labor and other related issues, and least concern for safety and all that. In fact, Professor L.N. Dhyani, who was a prominent person at that time, he was able to gather the people and then made a representation to the Factory Commission, to the State Secretary of India, and it was brought the evils of the modern factory system. Then the government formed a factory commission was formed in 1875, and the first Factories Act was passed in 1881. This Act, though it was passed in 1881, the workers were not satisfied, and this did not address very important issues pertaining to employment of children and women and the working hours. Then again further representations were made by Professor Dhyani and other group of people and made a strong recommendation. Then the Act was amended from time to time, considering the representations and looking to the actual aspects of various factors it was brought out. In 1911, the Act was amended in 1922, also implemented the ILO Convention of 1999 on hours of work. It was again amended twice in 1923 and 1926, considering these important points brought out by the workmen. Then Act was thoroughly revised and drafted in 1934 on the lines of recommendations made by Royal Commission of Labour, which was appointed in 1929. Next, redrafting was done, incorporated, and then the Factories Act 1948 has been brought into force, which is in force even now. So the Factories Act enacted in 1948 holds good today, except some amendments have taken place, minor amendments have taken place during 1948 until now. And as I said already, this is one of the finest regulatory legislation which really focuses on health of workers, the safety, then safety related to hazardous process, the welfare, the working hours, the restrictions on employment of young persons, annual leave wages, dangerous operations, safety and working conditions, dangerous operations, intimation of accidents and certain diseases, and even obligation and right of workers. These are the main chapters have been incorporated in this act. But simultaneously, we have to look into and study the rules pertaining to those obligations. Actually, the rules, factory rules, provides a very elaborate points for compliance in each and every obligations. It gives a lot of technical information as to particularly regarding the safety aspects of it, and then the hazardous process and dangerous operations. It gives very elaborate technical specifications. So, in order to ensure that you follow the entire Factories Act, you have to actually read the main obligation and the connected rules which details everything. So, this is the main gist of the Factories Act. But I would like to take you through, I will not take you through the technical details what is required here, because it's a very elaborate thing. But what I am going to tell you is the main chapters which deal with the Factories Act and the obligations thereafter, Then you need to always correlate the obligation by reading the relevant rules made by the state governments. Now, Factories Act, it has got the chapters like definitions, the inspecting tab, health, safety, hazardous process, welfare, working hours, employment of 8 persons, annual leave wages, special provisions, penalties and supplemental. Now after this 1948, now recently last year, the government, central government thought it appropriate to bring a very detailed comprehensive amendment to the Act itself. In fact, the draft bill was prepared, was circulated, and the bill also was supposed to be placed before the Parliament. Of course, nothing much has happened. Again, the information is that again one more bill is being drafted. A comprehensive bill is drafted to rationalize the entire system, safety aspects in Factories Act, taking into account the latest technological innovations and also use of various types of hazardous and dangerous articles are being used, and particularly keeping in mind to see that how best the pollutions are avoided and the society is kept as comfortable as possible. From this point of view, actually the bills are in the offing and we have to see how it going to take place. Now here, I will just touch upon the important aspects of the definitions. Adult means very clear, a person who has attained 18 years of age. Adolescent is between 15th year of age and 18th year. Calendar year means a calendar year meaning of January every year. A child means a person who has not completed 15th year of age. Hazardous process means, actually in the acts there is a schedule which is the nature of industries, the type of industries which is classified under hazardous industry. Those fall in the category of hazardous process. Mainly the material, the cause material impairment of the health of the persons engaged in connected with the and also results in pollution of the general environment. Young person means a person who is either a child nor an adolescent. Day means a period of 24 hours beginning at midnight. A week is defined as beginning of midnight on Saturday. Power means it can be any type of energy, any other form of energy which is mechanically transmitted but not generated by human or animal agency. Normally, the power is mentioned in terms of horsepower. Prime mover means any engine, motor or appliances which generates or otherwise provides power. A transmission machinery means any shaft, wheel, drum, pulley, system of pulley, coupling, clutch, etc., which is used to transmit or receive any machinery or appliance. Then machinery means it includes the prime movers, the transmission machinery and all other appliances whereby power is generated, transformed and transmitted as applied. Now here the important thing is the definition of worker. The definition of worker is very wide enough here. It says that a person employed directly or by or through any agency, including a contractor. The important thing is with or without knowledge of the principal employer, whether for remuneration or not, if he is connected with the manufacturing process or found in the factory, he is deemed to be a worker. So what happens here? There is no classification. Everybody is a worker, right from the manager. Everybody is a worker under the Factories Act. And even a person found through a subcontractor, a subcontractor engages with the knowledge or without knowledge occupier, then he was also deemed to be worker under the Factories Act. Because there are a number of cases where even the contract labor have been met with an accident and the companies have been prosecuted. As I said already, the definition of worker is very wide enough to cover everybody who is in the premises or presence of the factory. Now, what is the presence of the factory? Okay, earlier that I will discuss with you about the definition of factory. Definition of factory means any premises including precedents thereof. Precedents means the surroundings and the area, not only building, the vacant place also belonging to the company, surrounded by a fence or a compound, is also a precedence of the company. It means that includes buildings and covers the open space also as precedence. If 10 or more workers are engaged with the aid of power, 20 or more workers engaged without the aid of power, or factories under the Act. Now in the proposed amendment, they want to increase the 10 is being replaced by 20 and 20 is being replaced by 40. This is the proposed amendment we have to see. Now for computing number of workers, for all purposes, all workers in different shifts working should be taken into account for the purpose of calculating the number of workers in the factory. Now the next definition is manufacturing process. This is an extremely important definition of manufacturing process. Actually, this determines whether the factory, whether the establishment comes under factory sector or not. This is the most important aspects of defining what is a factory. Wherever the manufacturing process takes place, it is a factory. So the word manufacturing process has been defined very elaborately. It means that it is making, altering, repairing, ornamenting, finishing, packing, oil, washing, all activities have been added here. And prepare similarly, pumping of water, pumping of waste, sewerage is also comes under manufacturing process. Then generating and transmitting power is also a manufacturing process. Then composing and printing is also as a manufacturing process. Then constructing, reconstructing, repairing, refitting, refurnishing, breaking of ships, vessels, etc. is also manufacturing process. Then preservation of storing cold articles in cold storage is also a manufacturing process. Now here the definition looks quite exhaustive. It gives a very detailed process. But even then, this has been subjected to a lot of legal scrutiny and interpretations by various courts, even under this also. Then, in other words, to summarize, the factory means it includes a precedence as defined. Then it is power with power or without power. And next thing is, the important aspect is manufacturing process. Now here, important one, I will just give for illustration examples to enable to appreciate what is the manufacturing process. I will just give one or two examples of the cases so you will be able to appreciate the definition in a much better way. For instance, a dry cleaning process, a laundry, a dry cleaning process. It does manufacturing process because the cloth goes through various processes. The cloth is taken, put in the washing machine, then it is rinsed, it is dried, and then it is taken out, and then ironed, everything. So it goes through a process, hence it is a manufacturing process. For instance, in fact, in one of the cases in Tamil Nadu's water supply board, in this case, it has been held that even the supply of water is a manufacturing process, because in the definition of manufacturing process, you know that the pumping activity is involved. So here also, since pumping activity involved in the water supply sewerage board is a factory once again. Then, for instance, in fact, this one of the case came up in many cases where the kitchen has been held to be a factory. because in the kitchen, manufacturing process takes place because you convert the raw material into a process, finished food. So it goes through a lot of process. So it is a manufacturing process, and moreover, to prepare food, you use power. The power can be electric power, or it can be even LPG power, or it can be steam. Then what happens? Both combinations are there. It has been held that the canteen, the kitchen, wherever it is there, it amounts to a factory and definition. Similarly, pumping process in a petrol pump, it falls under Factories Act. Then transmitting power, it amounts to manufacturing process. Then in the case of PAD, Paddy Company, Madras Court held that packing of bulk products in a godown is a factory because here the complete finished goods comes in bulk to the godowns. In the godown, they unpack it and then again repack it and then send to different customers. Hence this process comes under packaging, hence it is a factory under the Factories Act. Now this is in short, I have given you some examples, but there are n number of examples for this. And to tell you, even the sweet making shop, for instance, jalebi making has held to be a factory. A person was preparing jalebi, employing more than 20 persons on a wholesale basis. It was held to be a factory because he uses power. Power means LPG. So it is a manufacturing. So these are some few examples of manufacturing process. So next thing is occupier. Occupier in the Factories Act is a very important person because he is the person who is mainly responsible for implementation and observance of the various provisions of the Act. In case of a partnership, one of the partners shall be the occupier. In case of a company, one of the directors shall be deemed to be the occupier of the company. Then it also specifies the general duties of an occupier. See here, as I said already, the position of occupier is extremely important because he is the main person who is responsible for the implementation, observance of the entire provisions of the Factories Act, including safety, health and welfare of workers. Though every occupier must ensure that as practical as possible, reasonable and practical health and safety welfare of the workers should be taken into account. He must maintain the plant and systems in a very safe condition without any risk. He must ensure safety and absence of risk to health in respect of all materials and all the workers. And he also maintains the provisions of monitoring such working environment in the factory for the workers that is safe and without any risk to health. The provision of such information and instruction, training and supervisions are necessary to ensure health and safety of workers at all work. Every occupier should also prepare a written policy on health and safety of workers. This is an extremely important thing and one of the main duties of an occupier. In addition to that, special responsibility is also put on the occupier. He is responsible for, as reasonably as practical, that the article designed and constructed in the factory are to be safe without a risk to the health of the workers when properly used. To carry out and arrange for carrying out such tests and examinations to ensure that such process or methods or type of manufacturing is away from the risk. Any person wanting to design and manufacture any article in use in factory may carry out or carry out such necessary research with a view to discover and as far as reasonably practical, elimination, minimizing of the risk to the health and safety of workers to which design or article may give risk. So here if you see all these things, a lot of responsibility has been put on the occupier to ensure that right from designing, manufacturing, testing and ensuring that the material is quite safe in all respects, even at the time of manufacturing or even at the time of commissioning. Now, this provision is proposed to be amended also to include, they want to expand the responsibility of occupier even outside this also. What they were proposing now is that the responsibility shifts up to even the erection and commissioning of the goods that becomes under the purview of the occupier. Because the goods are manufactured, but when it is taken for commissioning and erection at the customer side, at that time also he must ensure that all safety precautions are taken because he should not cause any safety hazards to the people who are working there and the people who are going to work from this factory and even the general environment. So this is an important responsibility. Now here, the definition of ordinary rate of wages for payment of allowance is also another important thing under section 59 of subsection 2. Here normally the overtime has to be paid twice the ordinary rate of wages. So what is ordinary rate of wages has been defined under this. So it is an inclusive definition. It contains the basic wages plus all allowances also. That's very important. So if we do not pay overtime on the gross salary, it becomes illegal. This has been approved by the Supreme Court in the case of government mint case in Calcutta, and Union of India Workers Association in 1961. It has been approved, and so we must bear it in mind that the overtime allowance shall be paid on the gross salary but not on the basic and D. Now here the amendment, as I said already, there is a proposal to amend the definition of the hazardous process. They want to replace the word hazardous substance instead of hazardous process, because the important thing is that hazardous substance shall have the same meaning as defined under the Environmental Protection Act. Here the hazardous substance means any substance or preparation of which by reason of its chemical or physiochemical processes, properties of handling is liable to cause harm to human beings, other living creatures and plants, microorganisms and property or the environment. So they want to expand the process, and they want to include the use of substance. So if you keep any substance for any process inside the factory which causes all these things, then it falls in this chapter of hazardous substance. This is a proposed amendment, and after it goes through, this will be expanded as per the definition. Now regarding employment, as far as updated workers are concerned, 18 years and above, no problem. Yes, you can definitely employ subject to the stipulation, the provisions under the Act. Then children below 15 years of age is totally prohibited. So you cannot, no one can engage child labor, and also it we have to go through the child labor also, which prohibits engagement of child labor. Then young persons between the age of 15 to 18, yes, you can employ in factory, but you have to comply with the special conditions as stipulated in chapter 7, there is employment of young persons. There are a lot of conditions have been put to employ young persons. For instance, you need to take a certificate of fitness by a certifying surgeon. That fitness certificate has to be renewed every year, and no female or worker, adolescent worker can be engaged in the night shifts, and the working hours shall not exceed more than 4.5 hours, no night shifts, and no female child will be allowed required in the factory in the night shift. The notice of periods of work for children is separate, and register of child workers is separate. So with these conditions in mind, you can engage young persons. But again, I emphasize that you have to go through the rules pertaining to this, which elaborates in more detail about the employment of young persons. Now coming to the chapter on health, actually as I said in the beginning itself, you need to read each section with the relevant rules. The section says, the premises shall be kept clean and free from effluent arising from out of any drain or other nuisance. Accumulation of dirt and shall be refused to be removed daily with sweeping or effective remains, keeping stairs and passages clean. It means that you need to keep the entire premises in a most clean and hygienic manner. The rules elaborates very clearly what are the frequency of it, how it should be cleaned, how it should be disinfected. It provides very clear, detailed information. Then regarding disposal of waste and effluents, it is also covered under the legislations pertaining to Environmental Protection Act. So any factory has effluents or waste generated in the process, it has to be treated properly in line with the Environmental Protection Act before disposal. Then it also stipulates conditions like ventilation and temperature. What are the ventilation standards and temperature will be maintained in the entire factory is also separated very in detailed manner in the rules. Similarly, dust and fumes. Effective means of exhaust system to avoid inhalation by the workers, because dust and fumes cause a lot of health hazards, particularly occupational diseases that it may occur on the time. Here the law is also emphasizing on the size of number of people to be engaged in the factory in a particular room or particular area, because they have to ensure that overcrowding does not take place. Here the law also says that 500 cubic meters for every worker should be set apart from the area required for the machineries. So this has to be taken care of. It means that, as I said already, meticulously everything has been defined under this act as far as health is concerned. Similarly, lighting. What should be the intensity of lighting? That is also specified and it should be taken care of. And drinking water. It has been specified that what is the quantity of drinking water should be made available, and particularly during summer, the cold water has to be supplied. This is also mandated in the act. Then section 19, if you go to retention units, here also it says, the rule says that what is the number of retention units should be provided separately for men and women, how it should be covered, and then what should be the periodicity of lime washing or painting and disinfect and then wash, etc. And what are the records to be maintained has also been specified under this legislation. Now coming to safety, this provides, as I said already, this gives a lot of technical input to maintain the safety and near the machines, etc. But I just glance, I will just give you the important aspects of it, because it has to be read along with the rules which defines in a very detailed manner. Now here is a fencing of machinery. He said the provision details very clearly, very elaborately about the fencing and guarding of machines in order to prevent accidents. When work are near in machines in motion, what should be the precautions to be taken when a person works near or near machine? Then particularly in the employment of young persons is prohibited in certain processes, hazardous processes, you cannot employ young persons. Similarly, striking gear and devices for cutting off power, this is the safety device has to be provided. Then self-acting machines, the provisions provide guidelines for safe operation of self-acting machines. Then similarly causing new machinery, this provision stipulates to conditions on state and central government specify further conditions on this matter. Then prohibition of employment of women and child labor near cotton mills. This applies mainly to textile mills where they are totally prohibited near cotton openers. And the hoist and lift. So this is an extremely important safety aspect in the Factories Act, where the responsibility is put on the employer to ensure that the hoist and lifts are kept in absolute safe condition. Periodic test has to be conducted, and periodic reports has to be conducted by a competent person and filed. Similarly, in case of lifting machines, chains, and then pulley blocks and lifting tackles, all these things must be periodically tested by a competent person and record to be maintained. This is an important obligation on the part of the occupier. Section 30 to Section 37, it elaborately conveys the various stipulations under the Act. To take you through at a glance, in case of revolving machinery, then floors, stairs and means of access, pits, sumps, openings in floors, excessive weight, protection to eyes, precaution against dangerous fumes and gases, precautions regarding use of portable electric light, and explosive or inflammable dust or gas, etc. These sections from 30 to 37 provides detailed stipulations. Again, as I said already, it is supported by the rules which elaborately conveys everything. Particularly much emphasis has been placed in section 38 regarding precautions in case of fire, because they are an extremely important aspect. If you see the rules pertaining to the precaution in case of fire, it's a very elaborately dealt with in terms of what is the type of fire and what are the type of extinguishers we use, how many extinguishers we use, and what are the type of training to be given, and what are the emergency plans, how are the emergency boards should be displayed, etc. All these things have been elaborately dealt in the factory's rules itself. Then appointment of safety officers. Any factory employ more than 1,000 people, 1,000 workers, they have to employ a qualified safety officer. In case of industries engaged in hazardous process or dangerous operations, it can be reduced to even 500. But the amendment also stipulates that, the amendment proposed now stipulates that the state government has got powers to appoint safety officers even in case of less than 500 workers, where it decides that the requirement of safety officer is there, considering the dangerous and hazardous process involved in such factories. Then again it stipulates the road safety in the factory premises, because this is also extremely important for internal movement of the traffic in the factory premises, because many times it may result in fatal accidents due to these instances. And it also stipulates the factory premises. Under section 53 of the Act, there are 12 different types of manufacturing processes. Each process have been separately dealt with in terms of various safety precautions to be taken. So one has to study the relevant schedule with reference to the type of manufacturing process in the unit. Then safety in pressure plants, it is taken care of in section 56. Protection to ice is section 58, and fire protection, I told you already, it gives elaborate procedures. Then in case of ovens and dryers used in the factory, rules have been specified, and in case of fragile roofs, the rules also has very clearly. And examination of eyesight for certain workers, it has been specified, for instance, the crane operators, locomotive or forklift operators, trucks, those who give signals to crane operators, they have to be examined every 2 years and maintain the records in a prescribed format. Then it also talks about safety committee in case where the number of workers are more than 250. Then the quality of personal protective equipment for safety should be certified by ISI. These rules elaborately deals with that. Then important thing is the health and safety policy to be drafted, to be approved by the occupier, and shall be prominently displayed and implemented in spirit. Then information to industrial waste to be intimated to the Pollution Control Board, this is also mandated. Then medical examination of all the workers who are engaged in hazardous process as periodically stipulated into the rules, and also maintain the health records and maintain it and evaluate periodically the status of the health of the workers involved. Then institution of occupational health centers where the hazardous process is there, and the rules also elaborately says that what is the number of staff to be provided in the occupational health centers depending on the number of workers. It also gives a list of medicines and other things to be kept ready in case of emergency. So all these things have been elaborately mentioned in the rules. Then in case of the hazardous process, the system of decontamination facility, this also should be provided in every factory. And also to supervise the operation of hazardous process, the supervisors, their qualifications also have been specified in the rules. So the person who has special qualifications to handle the hazardous process or materials only should be employed in order to ensure they guide and supervise the workmen in the factory under their jurisdiction. Then first aid boxes, it specifies the number of first aid boxes, and also it specifies the contents of the contents in the first aid boxes. It should be readily available at all time. Then in case of new factories, if they have to set up involving hazardous process, there has to constitution by state site appraisal committee has to be constituted by state government, and the application has to be put before the site appraisal committee. The committee will go through the entire process proposed to be manufactured, and then only clearance will be given. Only after clearance is given, the factory needs to start up, otherwise no. Now here, the occupier of every factory has to disclose who is engaged in hazardous process shall disclose in the manner prescribed the entire processes, the safety precautions to be taken, and handling of the emergency situations, not only to the worker but to the local authority and as well as the public in general. Then it's also responsible to the occupier with the approval of the chief inspector of factories. He has to draw out on-site emergency plan and detailed disaster management plans. This is to be drafted, approved by the chief inspector of factories, and this should be made known to everybody in the factory, including workers, everybody, and also the community, that is the community in which the industry is located. They also should know the type of hazardous what is being manufactured here and what are the emergency plans and evacuation plans. It has to be known to the general public also. The law is very strict on this. Any employer who does not do this, it can result in even cancellation of the factory license. This is how it is there. Then it is the sole responsibility of the occupier to maintain the health records of all the workers engaged in hazardous process, then health checkups, then appoint person who possesses qualified experience in handling hazardous substance extraordinary and are competent to supervise handling within the factory. Then in case if the emergency, in case the systems established in a factory is inadequate, if this factory inspector comes to a conclusion that the facilities and property is inadequate, then the state government is empowered to appoint Director General of Factory or Service and Labour Institutes or any institutions specified to study the revised standards. And in the Act also it says the permissible limits of exposure of various chemical and toxic substances that have been indicated in the second schedule. So the occupier has to keep it in mind that any substance or any material what he is keeping should be within the permissible limits as specified in the schedule of the Act. Then workers' participation in safety management. It constitutes safety committee as it already promote cooperation between the workers and the management, maintaining proper health and safety at work, and to review periodically the measures taken on that behalf. The composition and the manner of electing people and tenure shall be described, shall more prescribed in the rules by the respective state government. And here the workers also have got a right to inform the occupier if there is imminent danger in the process. No, they did not keep quiet. They got a right to tell the occupier about the imminent danger in any process. So this is about the health aspects of it. Now as far as welfare is concerned, again, it starts with section 42 to 48. It talks about the washing facility to be provided, then suitable sitting arrangements to be provided, where the members, where the workers are obliged to not obliged to sit in a standing position in order to take advantage of any opportunity for rest which may occur during the course of their work, and first aid appliances, I told you already. Then there shall be a canteen maintained by them if the number of workers are 250 more. The state government shall form rules regarding this, in the sense that what should be the size of the dining hall, what are the facilities to be provided, and then the plans to be approved by the chief inspector of factories, and constitution of canteen managing committee, how the prices to be decided, and what are the rates to be fixed, menu to be fixed. Everything has been detailed in a detailed manner in the rules appended to this. Then in every factory where more than 30 women are employed, the employer has to have a creche for the children up to the age of 6 years. Then here also the state government formulates the rules very, very elaborately in terms of what are the standards of creche to be maintained, the size of the canteen, and the number of people who attend it, and supply, how the hygienic standards to maintain. Everything has been specified in the rules. Then, if in company, in establishments, in factories, employ more than 500 workers, the welfare officers to be appointed. Here also, the number of welfare officers to be appointed shall be as per the rules prescribed by the state government. Then, working hours for adult workers. Here, section 51 to 55 regulates the working hours for adult workers. That is, not more than 48 hours in a week, and then they are entitled for weekly off, because that is weekly holiday. If a worker has to work on a weekly holiday, he has to provide a substitute holiday before 3 days or after 3 days of such weekly off, and ensuring that he doesn't work more than 10 days continuously. And in such case, an intimation also should be sent to the factory inspector of the information. Compensatory holidays in cases of continuous process industries where weekly off is not possible to give, the weekly off can be accumulated over a period of 1 or 2 months, and then subsequently he can use it within the prescribed limit. Daily hours should not exceed more than 4 hours. Rest interval should be minimum half an hour, and interval not to exceed 5 hours of continuous working. Then also it says that the spread over shall not exceed 10.5 hours on a day. Then section 28 says that work shall not be carried in factory by a system of shifts. So arranged more than one relay of shift engaged on the work of same. It means that overlapping of shifts is prohibited. Overlapping of shifts is prohibited. But you can seek permission from the factory inspectors or chief factories in case of absolute requirement in terms of manufacturing process. Then section 58 talks about extra time for overtime working. That is twice the normal wages, rate of wages has to be given. I told you already, rate of wages means it's inclusive of all allowances, it's a gross salary. On that basis it has to be given. Then notice of periods of work has to be prominently displayed on the notice board, and register for adult workers should be maintained. Then there is prohibition of double employment. It means that a person who works here, he cannot work in another factory or another establishment on the same day. Now here, there is also provision made. A state government has been empowered to make specific rules for people holding positions of supervision and management and holding confidential position for exempting from the application of provisions of this chapter. Because of the nature of work, because the responsibility they carry on, they need to stay beyond the stipulated hours, and they need not pay overtime, but they have to follow. In this aspect, the state government shall formulate appropriate rules for this, and each employer is supposed to maintain the list of persons holding supervision and management and holding confidential positions, and they need not be paid. These provisions will not be applicable to them. But at the same time, if the salary is less than the prescribed limit of payment of wages, then overtime has to be paid, irrespective of the fact that there is a manager or a supervisor. It has to be borne in mind. Now we know that the payment of wages, the limit is fixed at 18,000 rupees per month. So if a supervisor is getting less than 18,000 rupees per month, even though he is holding position supervision, the overtime will have to be paid as per the Act. Then the workers engaged in urgent repairs from the provisions of all this, their working nature, preparatory complementary work, these are all implied permission, exemption have been given by the state governments. Here also limits have been prescribed. If, for instance, a worker had to be engaged on overtime, sometimes urgent repair of machineries, breakdown of machineries, and in such emergencies, people had to work on overtime. At that time, they did not seek prior approval. There is deemed approval or deemed permission as granted by the state government. but the limits are there. It means that the daily hours should not exceed 10 hours, spread hours should not exceed 12 hours, number of hours in a week not to exceed 60, and overtime hours shall not exceed 50 hours in a quarter. With these conditions in mind, there is a deemed exemption for engaging workers on overtime for these activities like urgent repair works from the Projects Act. Then sometimes what happens many times, people also come out with exceptional pressure of work. Suddenly a gut of order comes, suddenly a rush of order comes, urgent deliveries are insisted. In such a situation, the government has got, state government has made rules, they given the power to chief inspector factories where they give exemptions from the sections of 51, 52, 53, 54 and 55, 56 for to engage workers on overtime for to deal with exceptional pressure of work. Normally the overtime exemption is given for a period of 3 months subject to certain conditions and laid down by the inspector of factories. Here the limits are the total number of hours shall not exceed 12, spread hours shall not exceed 13 hours, then weekly working hours shall not 60, then total of OT hours shall not exceed 75 hours in a quarter. With these stipulated conditions, the overtime exemptions can be obtained for exceptional pressure of work. And if anybody does the overtime without obtaining the permission, exemption from the similar factories for this purpose, then it will be illegal and you will be contravening the provisions of the Factories Act. Then further restrictions on employment of women. This is a very, very important section 66, where the women have been prohibited to work beyond 7 p.m. in a factory. But actually what happened, this section has been struck down by Madras High Court in the case of Vasanta versus Union of India in 2000 itself, and the court has held that this section is ultra vires because it violates the fundamental rights, because anybody has got liberty to work, so nobody can restrict it. Then the court came to the conclusion that this is an unreasonable restriction on women engaging in night shift, and they struck down. But of course, this High Court also said that it does not mean that the women are exposed to risk. It is a responsibility to provide such safety facilities and requirements to ensure that they are taken from the factory to their residences in a very safe condition, in a secure atmosphere, and all these conditions have been stipulated. In fact, arising out of this decision of Madras High Court, the central government is contemplating to amend this section suitably. Now, coming to leave with wages, here the workers are entitled for 1 day for every 20 days work, and if they have worked for 240 days during the previous calendar year, then leave shall be exclusive of all the holidays. Then proportionate leave in case of leave who is joined on any day other than 1st January, if you have worked for 2/3 of the total number of days, the remainder calendar year he has to give in proportionately. Then leave is entitled to in lieu of in case entitled to leave, wages in lieu of quantum of leave in which he is entitled immediately before his discharge or dismissal and quitting the employment or superannuation. So here the unavailed leave can be encashed in these contingencies. When a person leaves the organization with all these reasons, he is entitled for encashment. The number of leave that may be carried out to succeed shall not exceed 30 in case of adult workers, and worker has to give 15 days notice be given before he avails the annual leave. The number of installments of leave is restricted to 3 numbers. The annual leave may be adjusted against absence in case of any illness. So this deals about the annual leave wages. Then wages during leave period shall be full-time earnings. It means that when a person applies for leave, he is entitled for all the benefit, whatever the salary he would have got as if he had worked, except of course the overtime allowance and bonus. And if he wants the leave with wages to be paid in advance, the worker is also entitled. Before he proceeds on leave, if he wants encashment of advance salary on account of this, it can is also permitted, provided the leave taken is more than 4 days. Now here, Section 86 also provides an exemption for public institutions. For instance, now any educational institutions or technical institute which is also installed machineries and make some products, but with a view to train and impart training to students, then the government can exempt from the provisions of the Factories Act, but the conditions, service and other things shall not be less favorable than what is stipulated under the Act. They did not register as factories, but they had to form rules not less favorable than what is provided. It means that they have to take care of all safety and health standards as stipulated in the Factories Act in their own rules. Then it can, for instance, NDDF or CMDI or 4-1 Institute, like for instance, I'm giving examples. They need not be factories, but with these conditions, they can get the exemptions. Now, coming to dangerous operation, there is a special provisions instituted some time back. These are very, very elaborate process. In fact, there are 32 operations have been listed as dangerous operations. Now, each dangerous operation have been elaborately dealt with in the rules pertaining to the obligations on the part of the employer with respect to handling, manufacturing process and considering the safety and health of workers in the entire process. This is a very, very elaborate process. You have to go through in the sense that whichever the dangerous operation applicable to your establishment, you have to study the particular rules with respect to that and then follow. This is extremely important, and even if fatal accident takes place or any injury takes place, whether it is visible injury or invisible injury, it can be occupational disease also, the occupier shall be held responsible. So we have to go through this very, very elaborately in detail. Then of course, notice of accidents in case of bodily injury which results in absence of more than 48 hours, you have to inform the factory inspector. In case of fatal accidents, information must be given immediately to the factory inspector, the local district magistrate and the police sub-inspectors of jurisdiction, and also immediate relatives of the deceased. Then in disease also you have to notify. In other words, if you come across anybody has got occupational diseases, then immediately a notice of accident, notice of certain diseases has to be intimated to all the concerned to take necessary steps in this manner. Then power to inquire direct into the case of accidents. The state government or the factory inspector has got all powers to inquire into the cases of accidents or even disease, and they can hold the people responsible. Then okay, now this is the obligation by occupier. What are the obligations by the workers? The act is also quite active in this matter. In fact, section 97 clearly says that if the worker intentionally disobeys to wear personal protective equipments or does anything in contravention with the rules and regulations stipulated in his behalf by the employer or under the Factories Act, the worker can be punished in a criminal case. It means that a worker can be prosecuted under this, and penalties can be levied by the local magistrate. He is not immune to that. Now here, there is also section 101 says, exemption of occupier or the manager in liability in certain cases. What happens, in any case, in case of any accident, normally it is the occupier and the manager who will be held responsible. They may not be at the site, they may be sitting somewhere else, but the fatal accidents or anything will take place in the factory. So in such a situation, supposing the occupier has delegated his authority to the concerned manager in the shop floor fully to take care of all precautions, if he has delegated the authority to manage the entire thing, then the occupier or the manager can take some exemption from the prosecutions. Of course, there is a procedure for it, in the sense that when the case is launched before the magistrate court, before the case is taken up, an application has to be made before the public prosecutor by the occupier with an application to say that he should be exempted from this, and he has delegated and he has to produce sufficient proof and evidences in his behalf to say that a complete response has been given or given to the concerned manager or supervisor. He should be held responsible and not me. The court can consider such request and grant relief. Presumption of employment is there. Whenever a worker is there inside the factory, except during lunch hours, he is presumed to be in the factory in terms of work. Then the employer has also appeals, provision of appeals. In any order passed by the factory inspector against the occupier, he can make an appeal to the state government as prescribed, and then he can take care of his grievances or complaints or whatever of this. Then it also says display of notices and annual returns to be submitted. Then about the obligation of worker and right of workers. This is the in short. This is the contents of the Factories Act and its rules. I told you already, you have to read the Act along with the rules, because the rules are more prominently described than the Act. As I said already, this is a very, very important piece of legislation where even though the Act is very old, as back as 1948, even till today it holds good, because it technically worded and technically looks very sound. So, thank you very much.